Lawyers Association, Newcastle Chapter, Christmas event, at which we have the great pleasure of launching the book of our colleague and local academic, Kcasey McLoughlin. It's a special night for us tonight because we have the opportunity to celebrate some leaders in legal fields in our local area. And as women lawyers, we like to celebrate our own. My name is Ashley John. I'm a member of the Newcastle Chapter of the Women Lawyers Association. Before we start, I'm going to just make a few housekeeping announcements. So first of all, for anyone needing to use the bathroom, the toilets for the women, women to that way, men to that way. We understand from staff that masks are not needed while we remain in this area and while you're eating and drinking, but if you do move from this room, masks need to be reapplied. In the event of an emergency, please follow the directions of staff, but let's hope there'll be no emergencies tonight because we've got too much fun to be had. I have the pleasure tonight of welcoming our first two special guests. The first being our Lady of the Hour, Kcasey McLoughlin. Kcasey is an early career researcher and social commentator who probes the notion of gender difference in Australian law. She crafted her PhD thesis, critically interrogating the impact of gender within the High Court. Tonight, we're here to celebrate the launch of her book. In doing so, she'll discuss not only the questions explored within it, but also her journey to this point. Joining us together with Kcasey is the practical side of being a woman judge. And in that respect, I welcome Her Honour Justice Margaret Cleary. Justice Margaret Cleary was appointed as a judge of the Family Court of Australia in July 2010. Prior to her appointment, Her Honour had been a barrister for 23 years and a solicitor before that. Her Honour qualified as a family law mediator and arbitrator and conducted private and court-based mediations and arbitrations. Her Honour is a member of the advisory board of the Newcastle University Law School and is a member of the Australian Institute of Company Directors. She has a particular interest in companies in the family law context. However, Her Honour's most enduring interest is a focus on the protection and welfare of children involved in the court process through disputes within their families. Please join me in welcoming to the front of the room Kcasey McLoughlin and Her Honour Justice Margaret Cleary.
Good evening, everyone. Well, as Ash said, I'm here to be Exhibit A and an example of a woman judge. So I'll just have a couple of thoughts about that topic. When I was starting out, and it was still quite a novelty for women to be appointed to the bench, I used to think, how wonderful is it going to be when people don't comment on the fact that it's a woman who's been appointed. That sounded good to me. I also wanted women to be appointed who weren't necessarily the absolute peak of their profession, who hadn't won the gold medal, who weren't perfect. They were just ordinary lawyers who were appointed. All of that has come to pass. But after I became one, I realised that there was an international side to women judges that I hadn't ever really given much thought to. And I went along to one of those events, and it was extraordinary to meet women who were judges in countries where they might be one of three, really brave women who had been prepared to take the appointment. And when the awful events of Afghanistan occurred, we all got a message that said there was a judge in Afghanistan who needed to get out. It mobilised women judges and male judges the men all participated to assist her to do that. So there is I now think of it as the union between judges, between women judges at events who have said, it's so exciting to see so many people here who are all judges like me. So that was something I hadn't anticipated. Otherwise, being a judge is a privilege. Young women who are interested in the law should give serious thought to aspiring to that and thinking about what it would be like. I might just finish by saying that it is an exceptionally sedentary job. I had thought that my career at the bar was a fairly sedentary one. I now think it was a one full of exercise because I used to walk up and down from my chambers to the courts every day. Now, the walk from the door to the chair is about it's an isolating job because there's no avoiding the fact that you are in every way, not just within your own courtroom, held to a higher standard. And there's no Schadenfreude as great as seeing a judge in trouble. So there's that. But it's also an intensely satisfying job. You really open a window into the lives of the people who come into your courtroom, and whether they trust you, hopefully, or they're just there because they have to, you find out about their life. And people have said to me, you can write a book when you retire. I cannot. What I know about people's lives stays with me. But that's the privileged side of the job, so, which makes it enjoyable. Now we're going to hear from Kcasey about High Court judges, and ever increasingly women are being appointed to the High Court, and the current Chief Justice, I think, has impressed the country with her ability to efficiently deal with difficulties that she's encountered in a most impressive way. So I've had the privilege of reading a little bit of a précis of what Kcasey's written about, and it will be food for thought for everybody.
Thank you very much, Judge. I acknowledge that we meet on unceded or local land, and I pay my respects to elders past and present, and to any Aboriginal people who might be here tonight. I think, and anyone who has heard me speak here before will know this is my position, we probably should address the elephant in the room, and that is that we are in a gentleman's club, launching a feminist book. And this club, like the legal profession, was never meant for women. But my sense is that there is a capacity to disrupt places that were not meant for us, and that's, I think, an important thing to reflect on, and that's one of the things that I consider in my book. It's about the extent to which our legal system, the very architecture of our legal system, was designed by men, for men, and was exclusionary in the sense that not too long ago we had the 100th anniversary of women's admission to practice in this state, and there was a lot of triumphant talk about the fact that women have had an enormous ascendancy in that time. But one of the things that I'm interested in unpacking is the extent to which those hallmarks of its masculinist creation remain. And we see that in the actual manifestation of many of our laws, which have historically reflected a particular bias. I think, for example, today, with the passing of the affirmative consent laws, that's an example of a particular disruption when we think about the gendered consequences of law. And so I am conscious that I am here to spruik my book somewhat. So I'm going to read a little bit from the book. I should say that there are no hard copies of this book available in Australia. But not much of a marketer. There's a flyer at the front. It is available for order, and there's a discount code. It is obscenely priced as a hardback. I would wait till it comes out of the paper or buy an ebook, unless you're my mum. I will read a little from it to give a sense of what I'm really interested in exploring. Men in skirts and other dilemmas and disappointments. In 1987, Mary Genevieve Gaudron, a trailblazing woman lawyer, took her place on the High Court of Australia, the first woman to serve on the court since its establishment in 1903. She retired in 2003, well before her constitutionally prescribed retirement age of 70. In her farewell speech to Australian women's lawyers, Justice Gaudron, perhaps understanding better than most the complex gender politics at play in disrupting masculinist gender regimes, remarked that leaving the court was the best way of ensuring another woman would be appointed. Unfortunately, it proved to be otherwise. Her vacancy was not filled by another woman of legal standing, but by a man, Dyson Hayden, described by the then Justice Kirby as a most accomplished and civilised judge and man. Outside the High Court building, whilst his swearing-in ceremony was in progress, 2-year-old Vivian Clark and her mother staged a protest, not so much about the new judge in particular, but rather that his appointment meant that the court would be restored to its traditional composition of all men. The daughter held aloft a sign which read, "Mum, can women be High Court judges?" On the reverse side, the words, "Yes, darling, there was a good one when I was a girl." The then Prime Minister, John Howard, had justified the appointment on the basis of merit and suggested it would be quite unrealistic to choose people according to some strict gender or geographical basis when you're dealing with the highest court in the country. In any case, 2 years would pass before Vivian Clark's question received an affirmative answer. In 2005, the Liberal National Coalition government appointed Susan Crennan, and then followed in 2007 with the appointment of Susan Keefel. In 2009, the Labor government appointed Virginia Bell. In what might then be construed as a triumph for the politics of diversity and gender inclusion, these appointments meant that between 2009 and very early 2015, 3 women judges sat concurrently on a court which up until that point had been the almost exclusive preserve of men judges. The High Court of Australia, the highest court in Australia's judicial hierarchy, is comprised of 7 judges, meaning that 3 judges constituted a near majority. For a brief period in 2015, it looked as though near equal representation of men and women was to be short-lived, with Susan Crennan's retirement and the appointment of Geoffrey Nettle to replace her. But the appointment of Michelle Gordon in 2015, perhaps made more interesting given she was replacing her husband, Kenneth Hayne, on the bench, meant that the condition of a near equal gender balance returned. It had taken 84 years for the first woman to be appointed, another 2 decades for the second, and then the third, fourth, and indeed fifth woman arrived within 1 decade. Susan Keefel's elevation to Chief Justice of the High Court in 2017 marked yet another important milestone in women's access to legal authority in Australia. Affording a particular prescience to that protest scene staged almost 2 decades earlier, by mid-2020, Chief Justice Keefel presided over a High Court that commissioned an independent investigation following allegations that former Justice Dyson Hayden had sexually harassed 6 staff members, 5 of whom were judges' associates, during his time on the court, which was 2003 to 2013. These revelations were explosive. Although Hayden was by this stage retired and denied the allegations, his eminence and standing in the legal profession meant that he still loomed large as a prominent and powerful figure in the Australian legal profession. That the events in question were so intimately connected to his judicial role exacerbated the extent to which it reflected poorly on the High Court, both in terms of its inability to provide a safe place of work, but also a broader reflection of the legal system's failure to appropriately respond to sexual harassment and bullying. Whatever failings had permitted sexual harassment to go unchecked on the High Court, the Chief Justice's response, both in setting the inquiry in motion and her statement about it, made it clear that sexual harassment would not be tolerated. She offered an apology to the victims and in so doing acknowledged the difficulties in coming forward and emphasised, importantly, that they had been believed. For his part, Hayden denied any allegations of predatory behaviour or breaches of the law and in response to the inquiry commissioned by the High Court, Hayden's lawyers emphasised that the process was an internal administrative inquiry conducted by a public servant and not a lawyer, judge or tribunal member. It remains to be seen how these events will shape Keefel's legacy on the court, and that's something that I consider in this book, but it's noteworthy that her leadership has been widely praised. As for Hayden's legacy, his conduct has been widely condemned by those who've been willing to be drawn on it, but it remains to be seen how this reputational damage will inform his jurisprudential legacy. One especially high-profile exception to the widespread condemnation was former Prime Minister John Howard's comments in the aftermath, noting that he stood by his judicial appointments, describing Hayden as an excellent judge. What or who makes an excellent judge is doubtless in the eye of the beholder, but Howard's comments give weight to ongoing concerns about the lack of accountability and transparency when it comes to appointing High Court judges. More broadly, these revelations prompt questions about how the legal system sees and treats women, reflecting a concern that despite women's visible ascension to the peak of the legal profession, women remain marginalised within it. In this important respect, this moment of reckoning reignited questions about who our judges are, why that matters, and about the significance of and conditional nature of women's access to authority in Australia's constitutional framework. The historic first period of an almost equal gender balance on the High Court coincided with a time in which women also held peak positions within various branches of government in Australia. For example, at the Commonwealth level, Julia Gillard became Australia's first Prime Minister, Nicola Roxon became the nation's first woman Attorney-General, and Quentin Bryce served as Australia's first woman Governor-General. These achievements may well have demonstrated women's equal capacity to occupy the most senior positions of political power and authority within Australia's constitutional framework, but this must be tempered by acknowledging the gendered backlash that coincided with this state of affairs. Granted, much of the backlash was directed towards the first woman Prime Minister, and at least some of that can be explained by ordinary partisan politics. However, the gender criticisms of the Prime Minister and the sexism she encountered were visceral and often grotesque. As journalist Julia Baird described these instances, there were placards crying, "Ditch the witch," toys designed for dogs that encouraged them to chew off the fleshier parts of her anatomy, and a menu offering Julia Gillard Kentucky Fried Quail, small breasts, huge thighs, and a big red box. The particularly vicious responses which arose when she highlighted the sexism she confronted in her role demonstrate the precarious and problematised issues which arise when women exercise political power. In Prime Minister Gillard's experiences, and indeed in the revelations about Hayden's conduct, we are reminded just how deeply ingrained assumptions about gender relations and the regimes of practice built around them are within Australia's political and legal institutions. We are reminded, if such a reminder were needed, of just how easily past forms of gender entitlement could be reactivated and pressed into service. In terms of the gender dynamics of the High Court, it's fair to say that they were far less sensational than those in the parliamentary arena. But still, reflecting on the implications of Gaudron's retirement, Justice Kirby observed, inevitably, since her retirement, the High Court is a more low-key place. That the gender ratio or the gender balance of the High Court is noteworthy is of course itself reflective of the historical composition of courts as being exclusively the domain of men. It has always been a low-key place. Perhaps recognising this, Gaudron had attempted to downplay the historical significance of her own appointment by commenting at her swearing-in that she simply wanted to be one of 7. Given the circumstances, this was unlikely, but her comment is significant because it points to a problem that sits at the centre of this book. Namely, what difference it makes to the High Court when a woman enters the domain that was up until that time the exclusive preserve of men. And by difference, I don't necessarily ascribe to add women and stir version of difference. Women are different among and between themselves, and I think there are important arguments about women being appointed as judges on the basis of being representative in our political democracy, but I'm also interested in the ways in which our law reflects a particular gender hierarchy, and that's one of the things that I'm unpacking in the book, is not so much about a particular individual judge, but what it means for that institutional framework, the way that institutions are shaped by the gender order in which we exist. And I'm going to leave my reading there, but before I finish, I actually wanted to thank Women's Lawyers for the opportunity to host this particular event. And I, again, here's the brochure if you're interested in the book. It's available as an ebook and a hard copy. And the paperback will come eventually. I would suggest waiting for the paperback or buying an ebook. I'd also like to thank many of my friends and colleagues who were an enormous support during the writing of this book. And my family, who can't be here apart from the smallest member. My husband is caring for an older, noisier, more mobile child. But I would also like to single out Emeritus Professor Jim Joseph, who was my PhD supervisor and a really wonderful mentor and friend. And I'd also like to thank all of the women judges and the women pioneers and trailblazers who've come before us, because as much as I come at all this with a very critical eye about the extent to which things have changed, I also know that in lots of ways we have it much better than the women who came before us. So thank you very much.
Now Kcasey says she's not much of a marketer, so I'm going to help her out. Remember everyone, Christmas is coming. Do you have that difficult person to buy for? The answer is right here. The order forms are on the table, special discount, they'll never know you got it for free. Well, not for free, for cheap. We're getting big discounts here, Or there's that other wonderful thing that I don't know if other people enjoy doing it, but I certainly do. You order it now, it comes later, you totally forget, gift to yourself, everybody wins. Kcasey's done a good job of giving us a taste of what's in the book without giving it all away. The spoiler hasn't been revealed, so we're going to have to read the book to find out the rest of the research. Please join me in thanking Kcasey for joining us today and giving us the opportunity to share the launch of her book. We're really excited to do it. She's a leading academic in our area and we're so glad to support her in this, and we congratulate her for her achievements. As a small token of our appreciation and congratulations, I also thank Justice Cleary for joining us today and putting herself forward as the specimen. But then again, maybe she should thank us, because we helped her get a few more steps up today. We got further than just her daughters, her seat and into the courtroom. So you're on your welcome. So thank you both. I'm really pleased that today we get to celebrate yet another achievement for women lawyers. Now, Justice Cleary eloquently set out that we shouldn't just celebrate the achievement of women judges, we should not be excited that it's a woman who's been appointed. But what we're excited about is it's one or two of our esteemed local colleagues. It's my great pleasure this evening to make a toast to one of our two recent appointments, Her Honour Judge Julie Carney. Her Honour's sister, Judge Vivian Carty, was unable to join us today but has sent her apologies. Both Judge Carney and Judge Carney are accomplished lawyers. They were both accredited specialists in family law. They were then both called to the bar. What makes both of these ladies impressive and inspiring is not just their contribution to the law, but the way they balance that with their dedication to their families. In the ceremonial sitting a few weeks ago, both Judges Carney and Carty made reference to their families, to the importance of their families in their lives, and in the addresses at that ceremonial sitting, their families played such a large part in making each of them who they are today. They are hardworking. They've already demonstrated in the few weeks they've been at the bench their diligence to the role. We have every confidence that they have before them a wonderful career. It'll be hard work, but if any two ladies are up to the challenge, it's Judge Carney and Judge Carty. So please join with me in celebrating the appointment Judge Julie Carney and Judge Vivian Carty to the bench of the Federal Circuit and Family Court of Australia, Division 2. Well, that concludes our formalities for this evening. Oh no, it doesn't quite conclude our formalities. Judge Carney could come forward.
Don't need a microphone.
It's okay, we'll take you straight to the gift bags. A small gift from the Women Lawyers Association to congratulate both you and Judge Carty on your appointments, and I hope that if you get any downtime over the Christmas period, you might have an opportunity to enjoy it. So that otherwise now concludes the formalities of this evening. The final reason we're joining today is to celebrate that we can finally come together face to face, our group of really active women lawyers participants. We celebrate and support the males and females in the room. We're so glad that you've all been able to join us together. You're all very important members of our association. You're very important members of our profession, and we wish you all the best for this evening and a Merry Christmas to you and your families. Good night.